y'all. Back for week 3 of the P.E.A.C.E series. This week we're talking about the A in the P.E.A.C.E acronym for alimony. This is kind of one of the most frightening aspects of divorce, especially with the primary breadwinners that come to us for representation. And I find that one of the reasons it's scary is because it's most often understood by people. So let's first talk about what is alimony. Alimony is another word for spousal support. We all know what child support is. That's money that's paid by one party to the other party for the support of the child. Well, alimony is very similar. It's money paid by one party to the other party for the support of the spouse. In Florida, we have kind of 3 different subsections on alimony that we talk about. We have temporary alimony, durational alimony, and permanent alimony. Permanent alimony is what most people know of and what either half the community is seeking or the other half of the community is fighting against being ordered to pay. But before we even get to permanent alimony, I want to talk to you about temporary alimony and durational alimony. So in Florida, there's a presumption if you're married under 7 years that temporary alimony is really going to be the most that you're going to be able to get. Then we go from 7 to 17 years of marriage, and that's where a durational alimony, there's a presumption for that. And then after 17 years of marriage, we call that a long-term marriage. Usually the presumption there is for permanent alimony. So I'm going to take you through temporary, durational, and permanent to explain to you what each of those are. I also want to hit on how these presumptions might be rebuttable presumptions in certain circumstances, and then talk about a couple of other components of alimony. So temporary alimony, pretty simple, is exactly that. It's kind of a short-term alimony. There's different ways that the court can order this. They can do a lump sum payment, which is, let's say, you owe your spouse, say, $5,000 and that's it. Another type would be what we call bridge the gap. That's a situation where maybe the spouse who makes less money or who is unemployed needs a certain amount of money to get out of the marital home, maybe get into an apartment or move back to another state. So there's an identifiable amount of money that will help them get from the married life to whatever their life's going to look like after their divorce. So that would be bridge the gap. Another type of temporary alimony is rehabilitative alimony, and this one's kind of unique unto itself. This is a situation where maybe a spouse needs to finish their education to become employable, or needs to obtain some additional credits in their education to be able to have a degree to allow them to work and be able to maintain themselves financially. So the court, in some circumstances, will order rehabilitative alimony, but the court does require the party seeking rehabilitative alimony to submit a detailed plan of what it's going to take for them to be able to get from where they are presently to being at the end of their education to become employable and self-sustaining. So those are types of temporary alimony. A newer form of alimony that we have here in Florida is durational alimony. Durational alimony is a periodic payment from the paying party to the receiving party for a period of time not to exceed the duration of the marriage. So if you've been married more than 7 years, less than 17 years, the court can say party A has to pay spousal support to party B for a duration of time, but that duration of time cannot exceed the number of years of the marriage. So let's say hypothetically you're married 11 years. The periodic payment couldn't exceed 11 years in duration. Now, with durational alimony, the amount of alimony ordered is subject to modification down the road. If, say, the incomes of the parties change, or maybe the receiving party remarries, or, some circumstances dies. But the length of the durational alimony award cannot be modified. So that's just a little thing that's important to know when we're talking about durational alimony. Finally is permanent alimony. So that's pretty simple to understand. This is where basically the receiving party is going to receive alimony either until they remarry or they expire or die, unless there's some modification of the award of alimony down the road. And this is after parties have been married for 17 years. Permanent alimony, unless it's specifically written in whatever the final judgment or the mediation agreement is between the parties, usually is subject to modification down the road. In some circumstances, the paying party wants to retire and is of a retirement age. The court, under circumstances, will say, okay, they're going to be making less money, they're going to be paying less money as a result. The one thing is with the permanent alimony is almost every year for, gosh, the past, I'd say 7 years, a bill has gone up to the state Senate to basically do away with permanent alimony. So this video, while good right now, may change next year or the year after, the year after. They keep trying to do away with permanent alimony and basically come up with a formula which is kind of like the formula in child support that would help the parties arrive at an alimony figure and a duration of time that is not permanent. So maybe next year I'll be doing a new video on permanent alimony. Overall though, what the court is looking at when they're considering what to award as far as a payment of alimony, they're looking at, and this is probably the most important part of this video, what is the actual need of the party that's seeking alimony, and then what is the ability of the party that is being sought from to pay. So it's not what the party wants and what the other party wants to pay, it's what is the actual need based on a number of factors under Chapter 6108 of Florida statutes. That's our alimony statute. What does that party need, and then does this party have an ability to pay it? And it's not uncommon where one party has a need, a very clear need for alimony, but the other party just doesn't have an ability to pay it, in which case there may be no alimony award in that situation. I'm not going to go through the factors here with you. Again, Chapter 6108, for those of you who are interested in this, you can Google Chapter 6108 Florida statutes and it'll list the factors. Some of those are the standard of living during the marriage, each party's contribution to the marital estate, how involved the parties are with the raising of the children, these sorts of things. But again, if you're really interested in it, Google Chapter 6108 of Florida statutes, it'll go through those factors. Finally, in some cases, the courts can order a party who's ordered to pay alimony to take out an insurance policy or take out a bond to help protect that payment to the other spouse in the case of them becoming disabled or again, if they die. That way the other party is still able to receive that amount of money. So this is just a very broad stroke discussion of alimony in Florida. I could probably do 10 videos on alimony. If you guys have questions though, as I've told you before, please check us out on the website. If you're on YouTube, click on the link below. The website's got my email, it's got my office phone number. You're welcome to contact me and I'll answer any questions you might have. Next week we're going to talk about the C in the P.E.A.C.E acronym for child support. Hope you're enjoying these videos. See you next week.